The Honorable Justices of the Supreme Court. This court, from recess, now sitting.
Please be seated. I'll call 102-471, State of Kansas versus Rusty Sievers.
Mr. Sievers appears through counsel Michelle Davis. May I please reserve 3 minutes for rebuttal?
3 minutes. Thank you.
This is a speedy trial issue, and again, a question of statutory interpretation. And we're looking at the speedy trial statute that was in effect in 2008, 22-3402. And the issue in this case is that Mr. Sievers did not appear at a pretrial conference. He had been arraigned in early June in 2008, and then he failed to appear in late August for the pretrial. And the court continued to have the trial date on its calendar. The court did issue a warrant for him late in August. So the issue is subsection 3 of the statute says that if the defendant fails to appear for trial or pretrial and a bench warrant's ordered, that the trial should be rescheduled within 90 days after the defendant surrendered on the warrant. And then there's another sentence about if there's still the original 180-day time, if more than 90 days of that still remains, then instead of the 90 days, it would be the greater number that remained from the original 180 days. So what we're trying to figure out here is whether it's clear from the record that the court, when it rescheduled the trial, it didn't do so within 90 days after he was surrendered on the warrant. And so the state, in this case in the Court of Appeals, are basically saying that more than 90 days of the original trial time remained. And so it's okay that the trial judge didn't reschedule within the 90 days because the trial judge had more time to reschedule. And it's our contention that the reason that it was only 90 days left is because the court continued this matter for trial. It did not take the trial date off. So the court issues a warrant, and then trial counsel files a motion to continue the trial and a motion to withdraw in early September.
And what's the impact of that?
Well, because
of the continuance, because then you have 3402.3 that talks about a continuance from the original trial date. If it's requested and continued, then it's another 90 days, which actually was continued twice by defendant, as I recall. Why doesn't Section 3 kick in?
I'm just not sure I'm understanding your question.
Well, 22-3402 says that Section 3, if any trial scheduled within the time limitations prescribed by 1 or 2, which this was, is delayed by application or at the request of the defendant, the trial shall be rescheduled within 90 days of the original trial deadline. That occurred. And actually, it was a request for continuance, and then it was requested again, as I recall. Why doesn't that?
Well, I think I'm reading Section 4.
I know you're reading Section 4, but why doesn't Section 3 apply?
To preempt, because it has some more specific language that governs this circumstance. Because if you went by Section 2 and 3, and you didn't have Section 4, then the Court of Appeals logic would be correct, because once he didn't appear for trial and he's a fugitive, then any delay is his fault. And so under Section 2 and 3, all of that time until they reschedule the trial till January would count against the defendant. It's only the fact that we have Section 4 where it specifically says even if he doesn't appear for trial and he's surrendered on the warrant, the court still has to reschedule it. So I was reading that paragraph as being taking priority over any other paragraph.
But here you have counsel requesting a continuance.
Yes. And that's the reason, that's the delay then that I believe that you have to start attributing to the defendant. And they show up at September 12th and have a hearing on that motion. And the judge says, no, I'm going to leave the trial set for September 30th. The bondsman may still bring him in, and you have the rest of the month to prepare, and we can maybe still have a trial. And we're going to get together on September 26th. The state has moved for a judgment on the bond, and we'll take this back up on September 26th. And it's then when they appear on September 26th and the defendant's there that the judge doesn't say the words, but basically she continues the trial. Because at the defense counsel's request, he reschedules the pretrial till October. So it's our contention that you've got the June 13th arraignment. It's not until the court continues the trial on September 26th, when the court officially continues the trial. All that time's still going. And so that is more than 90 days. So then you have the subsection 4 that kicks in that says, once the defendant is ready to be rescheduled, it has to be within 90 days. And that's where you go to the October 10th date, where they've got everybody back in front of them, and the judge then at that point has to reschedule within 90 days, and that's what the judge fails to do. Yeah, I think Justice Rosen, I would have
All I
probably
said
have
is
to concede.
on September 12th at that hearing, counsel for defendant requested a continuance of the jury trial.
That's correct. That's right. And then the judge says, no, we're going to leave it set. We're going to still try to do it on September 30th. And so that's our contention then, that's still, that none of this is attributable to the defendant. This is still, until the judge moves it on September 26th, that's the delay then. That's at that point, according to Brown. The delay really is from the September 30th trial date until, but according to Brown, it's when the judge grants the continuance motion. That would be September 26th. So at that point, they've used up more than 90 days. They've used over 90 days at that point, and therefore the judge only has 90 days left to reschedule it. And then the judge doesn't do that when the judge goes to reschedule it. So I think our argument today is that subsection 4 takes priority. You can read subsection 4 kind of literally. And it talks about the trial has to be rescheduled within the 90 days after surrendered on the warrant. And then it says, if subject to the 180-day deadline and more than 90 days remain, you can take that literally and say it's more than 90 days from the point they're surrendered. But if we go back to the Section 2 and 3, what you were talking about, and it talks about the time running and the delay, then even with that language and applying those subsections to figure out how much time is left, you still got less than 90 days left.
Now, what date was the warrant issued?
Judge, the warrant, he fails to appear at a pretrial on August 22nd, and the warrant is actually issued on August 26th. The
Now,
trial date is still set. The trial date is still
I
set.
understand that. I understand your argument is that the clocks kept running against the state because the trial date was set, but under subsection 2, which was applying when he failed to appear, it speaks to a person that's held to answer on an appearance bond, and once that warrant issued, they weren't being held on an appearance bond, were they?
Well,
I mean, the warrant was issued because the court was revoking that bond, and so regardless of the trial setting, why wouldn't the time quit running under subsection 2 because he no longer qualified under that plain language?
yeah, and I'd have to look back at the record. I think the bondsman did bring him in close to that September 26th date. I think it was September 25th. And so I think at that point there's a hearing in the record where the bondsman then asked to be taken off the bond. And so maybe that's what you're talking about at that point.
Well, what I'm talking about right now is when the court issued a warrant, then I don't know how you say that the defendant was being held to answer on an appearance bond, because there's a warrant to arrest. If they find him that day, he's arrested, and he's not on an appearance bond, is he?
But I think the bond was still in effect because he didn't get arrested until that September 25th date. And then the bondsman shows up and the court relieves the bondsman on that September 26th date or somewhere around there. If memory's correct. So basically it's our contention then that it's just clear from the record that the state wasn't paying attention. When he appears, they all show up on that September 26th date. It's clear the defense requests more time. So they show back up on October 10th. and that's the date when they're going to reschedule the trial within 90 days, and the state just wasn't paying attention to that. There was a pretrial that was held early in December, and the state never raised a concern about the speedy trial time. And so this is a situation where they just weren't paying attention. They just didn't get into trial within the 90 days as required by statute. That concludes my comments.
Any questions? Thank you, Counsel.
Justice Luker, members of the court, my name is Douglas Matthews. I'm the Barton County Attorney. I represent the appellant, the state of Kansas, in this matter. At trial, or prior to trial, the trial judge granted several continuances to the defendant at the request of his counsel. Over and above that, the defendant decided that absconding for a period of time was in his best interests. The Court of Appeals took that into consideration when they determined that during those periods of time the clock stopped, and they properly held these delays or these continuances at the feet of the defendant. Given that and the statutory language, there is no reason for you not to uphold the decision of the Court of Appeals.
Why does the clock stop on the 22nd of August when he fails to appear, as opposed to August 26th when the warrant finally gets issued?
Because he failed to appear for a pretrial hearing. The hearing itself was set for the 22nd of August. That's when the court was in session. That's when counsel appeared for what they believed was going to be a hearing to discuss various legal matters and any issues that could be resolved prior to the time of the actual trial itself. In Barton County, these things are scheduled usually on a bi-weekly basis. So at the time of arraignment, back on the 13th of June, counsel and client would have known that the hearing date was coming up at a predetermined time on a predetermined date. That date was August 22nd. The defendant failed to appear for that hearing, and according to Kansas law, the failure to appear for the hearing is the action that stops the clock. Now, given the practicality of pushing paperwork across the desk so somebody can sign it, the warrant wasn't actually signed and issued until several days later.
And what's the basis for that statement, that the law says the failure to appear at the hearing automatically triggers a stay on the running of the speedy trial clock?
Again, Your Honor, I'm looking at Section 4 of 223402. The way I've read this and all of the cases that I've researched on this matter, if a defendant fails to appear at a previously scheduled pretrial hearing or the trial itself, we have a delay.
But it actually says if the defendant fails to appear for the trial or any pretrial hearing and a bench warrant is ordered. And I think that's where Justice Biles is asking you. It says, and a bench warrant is ordered. Why isn't that the triggering date rather than the date of the hearing?
Well, the bench warrant was ordered on the 22nd.
Just not issued.
It was not issued until the judge actually had an opportunity to sign off on it. But the order spoken from the bench was given on the 22nd of August. That's the date that the defendant failed to appear. And at that point, the clock stopped. Now, at that point, 70 days from the date of arraignment had passed. We still have 110 days remaining on that original 180-day clock. Excuse me. The defendant is arrested in late September. He's brought before the court the following day, and the matter is rescheduled for hearing, excuse me, in October. Now, we have an intervening event during the period of time that the defendant cannot be located. We have counsel without a client. She cannot discuss pretrial strategies with him. She cannot discuss witnesses to be called. She cannot discuss with him whether or not he is going to testify. And as she made clear to the court, she could not proceed without her client being available. She requests either to be removed from the case or to continue the trial date. Ultimately, that motion is granted. And then because a conflict is discovered, new counsel is appointed. Again, these are all delays attributable to the defendant. When trial is rescheduled, it's reset for this day, late day in January 2009, and that is within the remaining 110 days. I think we have one or two more that we have available to us, but the trial begins prior to the ending of that 110-day time period, and that's all the law requires. As long as we can start the trial, we've met the obligations under the Speedy Trial Statute. Because that was done, the Court of Appeals determined that the actions of the trial court were proper. The defendant was held accountable for the time that he caused in the delays, both by his absconding and by the continuances granted. And at the trial court level, it was determined that there was no speedy trial violation, and the Court of Appeals made that same determination.
After the bond revocation, was the bond reinstated at any time, or was he in custody?
He was in custody the entire time, after he was arrested.
But that had no effect on the number of days. If he had been never bonded, he had had a 90-day period.
If that had been the situation that had taken place at the time of the arraignment, the statute specifically declares if you're in custody at the time of arraignment, and we presume that that custody situation continues, the state has 90 days from the date of arraignment in which to bring him or her to trial.
And in other words, you're saying that if you have the 180 days applying to you at time of arraignment, then that never changes even if your bond is revoked and you're incarcerated.
It can change, but there's where we look to see how much time has passed, and there's where we look at subsection 4. If we have less than 90 days from the date of arraignment to the date of the delay, in this case absconding, if we're talking about less than 90 days, we have to reschedule that trial within 90 days. In this case, 70 days had passed. On the state's clock, on the court's clock, we still had 110 days. That 90-day barrier never came into play because by the workings of statute, we still had that time available to us, even though the defendant's custody situation had changed.
I guess I'm struggling a little bit with what got, I'm looking at subsection 2 and trying to figure out what got delayed and what's meant by the term the delay in the statute. Because if the delay is pegged toward the trial date, really that your trial date never changed until much later.
The trial date originally did not change. If I recall correctly, the judge was still hoping that our defendant could be taken into custody or brought into the control of the court, and we would still be able to have a trial within the, by the original trial date. That did not happen, and counsel had already made her request for a continuance. The thing that was delayed here was the trial. In part because the
Explain that to me. how did the trial get done? I mean, I understand from reading the transcripts of, I think it was the transcripts of the hearings, that the defense counsel saying, I can't prepare. I understand how that's being delayed.
Mm-hmm.
I understand how the pre-hearing conferences that the court has scheduled have been delayed. I'm trying to figure out what the delay, as referred to in the statute, means. I mean, it seems like it should only really worry about a delay of the trial date. And if there are some internal problems in between, how does that really impact anything? I'm just trying to read the statute.
I am too. I take it what we are concerned about is defendant disappears on day one, and 2 or 3 days before the trial, he reappears. Theoretically, we could still go to trial on the originally scheduled date. As a practical matter, that's not possible, because the last thing an attorney is going to want to do is proceed with a trial when she has not had the opportunity to consult with her client about trial strategies, witnesses, are you going to testify, and so on. I agree with you. If you wanted to simply look at the verbiage, has the trial itself been delayed? No, certainly we can continue the trial, we can proceed with the trial on that originally scheduled date, and there would be no problem. Except defense counsel would have a problem, because she would not have been given the opportunity to discuss these issues with her client and formulate a trial strategy.
I mean, the pesky problem for us is dealing with the language of the legislature and whether it's clear or not. And if it's clear, then that's what we're supposed to do, is follow the language in the statute. And I feel like you're asking us to insert some language into the statute.
Well, I think what I'm asking you to do is to take a look at the facts of the case and determine that the defendant, through his actions and through the requests of his attorney, caused delays or continuances to take place which cannot be laid at the feet of either the court or the state. Ultimately, when we talk about something being delayed in this case, we are talking about a delay of the jury trial. Now, that eventually took place, but it didn't take place until several months after it had been originally scheduled. But none of those delays were due to the actions of the court or the actions of the state. The defendant absconded, and he remained away for a fairly substantial period of time. In the intervening, counsel requested a continuance to meet those practical matters that she had to consider, lest she suffer a 60-1507 action. I need time to consult with my client. If we're talking about delay, we're talking about delay of the trial. And after he is returned to the state's custody, continuances are requested and they are granted, both to meet the needs of counsel and to allow for a change of counsel because of a conflict. Again, but for the actions of your defendant in this case, we would probably have been able to proceed with trial on the original date as scheduled. But we have several intervening events that caused delays.
It just what's troubling about this is that it's pretty clear the intent of the statute is once you're in custody, you have a right to trial within 90 days of being brought within custody. And here there's even more time, but once the pre-trial hearing on October 10th is held, trial is set not well, but 110 days after that date. Seems to defeat the purpose of getting a speedy trial once you're confined solely on the charge, which is what we have here. And I understand you say it kicks back under Section 4 to include the 180 days, but this goes beyond the 100. It really allows it to go beyond the 180 days, or beyond the 90 days, which is contemplated.
If originally we had been talking about the date between arraignment and the scheduled trial date, I might agree with you. But again, I can't help but look at the fact that delays are caused by the defendant or counsel in making these various requests. The statutory law itself allows for this sort of thing to happen. And it's the defendant who puts himself in that position when he doesn't show up for the pretrial hearing to begin with. I agree, we want these things to be held as quickly as possible, but if the delay is going to be caused, and it's at the cause of the defendant, the clock stops. And Your Honors, unless there are some additional questions, I'll submit the case.
Thank you, counsel.
I'd like to waive rebuttal unless there are questions.
Any questions of counsel? Thank you. Court will take this matter under advisement.
Thank you.